Welcome to McCabe-Curwood Video Case Notes. My name is Guy Lewis and I work in the Litigation and Dispute Resolution Group at McCabe-Curwood. The New South Wales Court of Appeal recently handed down an interesting decision that applied the contractual doctrine of election to a complex factual scenario in the matter of Donau Proprietary Limited and ASC AWD Shipbuilder Proprietary Limited. The decision serves as a useful opportunity to consider the principles of election as they apply to circumstances where a party must choose whether or not to exercise a right to terminate a contract. The Litigation and Dispute Resolution Group at McCabe-Curwood acted for Donau throughout the dispute with ASC, including at first instance before the Supreme Court and before the Court of Appeal. The proceedings concerned a contractual dispute between Donau and ASC as to Donau's entitlement to fees for the construction of various parts of warships for the Australian Navy. The parties entered into their original contract in 2009. The original contract set out a complicated performance-based formula by which Donau's fees were to be calculated, as well as provided a work scope approval process. Due to a number of design changes, defects and delays, many of which were outside the control of either Donau or ASC, in 2012 the parties entered into a new contract, the Second Heads of Agreement. The intention of the Second Heads of Agreement was to simplify the parties' contractual relationship and provide more certainty to their obligations, especially with respect to the mechanism for determining Donau's fee entitlements. Another important aspect of the Second Heads of Agreement is that it streamlined the work scope approval process when compared to the original contract. The Second Heads of Agreement gave ASC a unilateral right to terminate if the parties had not re-baselined the performance metrics by the 28th of February 2013. It was common ground that the parties had not completed the re-baseline by that date. ASC then purported to terminate the Second Heads of Agreement on the 7th of June 2013. Accordingly, an issue in the proceedings whether ASC had lost its right to terminate because it had elected to affirm the Second Heads of Agreement by acting in a way that was exclusively consistent with that agreement. In short, the doctrine of election comes into play in situations where a party must make a choice between alternative remedies or inconsistent rights. A common example of this is where a party is forced to decide whether or not to terminate a contract. There are two elements of an election to continue with performance of the contract. Firstly, the party knows that its right to terminate has enlivened. And secondly, the party makes it clear that it's chosen to insist on performance of the contract through either unequivocal words or unequivocal conduct. In this context, unequivocal means that the party's words or conduct is only consistent with the exercise of one set of rights and inconsistent with the other. In the proceedings before the Court of Appeal, Donau pointed to the fact that ASC continued to follow the work scope approval process under the Second Heads of Agreement, following the accrual of its right to terminate on the 28th of February 2013, rather than reverting to the work scope approval process under the original contract. Donau argued that this amounted to unequivocal conduct that could only be consistent with the decision to continue to follow the Second Heads of Agreement. The Court of Appeal found that ASC's conduct was equivocal. As the parties had been following the work scope approval process under the Second Heads of Agreement informally for some weeks before the Second Heads of Agreement actually came into effect, President Bell held that ASC's conduct in continuing to follow that work scope approval process under the Second Heads of Agreement after the 28th of February 2013 was equally consistent with the decision to continue following this informal process as it was to affirm the Second Heads of Agreement. Furthermore, President Bell considered that the following factors prevented ASC's conduct from the necessary unequivocal status to sustain a claim for election. Firstly, the parties continued to attempt to re-baseline the performance metrics after the 28th of February 2013. Secondly, the parties had a long history of operating outside the precise terms of their contractual arrangements. And thirdly, it was an implied term of the Second Heads of Agreement that ASC had a reasonable time after that date to exercise its right to terminate, but it was unknown to the parties at that time when that time would expire. The decision is a timely reminder to all contracting parties to communicate their intentions clearly after their right to terminate enlivens. If you are unsure whether to terminate the contract or persevere with it, and you want to buy time to consider your options, you should consider entering into a standstill agreement with the other party to preserve your right to terminate while you try to resolve the situation. Having acted for Donau throughout the dispute with ASC, including at first instance before the Supreme Court and before the Court of Appeal, we have a wealth of knowledge on contractual disputes, so please contact us directly if you require any more information. Thank you for watching.